Well, hello everyone, and welcome to another American Consumer Institute webinar. Today we have Thibaut Schreppel sharing his perspectives on the future of antitrust in the US. Before I go ahead and introduce Thibaut, I do want to say that everyone in the audience is in listen-only mode. And also a reminder for those of you joining us for the first time, the American Consumer Institute is a nonprofit educational and research institute committed to be a reasoned voice for consumers by improving the understanding and impact of public policies. If you'd like to learn more about ACI, please go ahead and visit our website at theamericanconsumer.org and subscribe to our newsletter. So I'm very delighted to be joined today by Thibaut. He is a faculty affiliate at Stanford University Codex Center and an assistant professor at Utrecht University School of Law in the Netherlands. He also holds research and teaching positions at the University Paris Panthéon-Sorbonne and Sciences Po Paris, as well as a PhD in digital antitrust law. He's also a Harvard University Berkman Center alumnus. In 2018, Thibaut was granted the Academic Excellence Global Competition Review Award, which recognizes an academic competition specialist who has made an outstanding contribution to competition policy. He has published a book on the subject of predatory innovation in antitrust law and articles at Harvard University, MIT, Oxford, NYU, Berkeley, and Georgetown, among others. So welcome, Thibaut. Thank you for joining us today.
Thanks a lot for having me.
I'm going to go ahead and jump right in, and I want to ask you, is antitrust law in need of a new framework right now? Does antitrust need rethinking? And more specifically, are there any particular or critical problems with antitrust law and enforcement that need to be addressed by a new framework?
Sure. So I would say the answer to that question depends very much on what you want to achieve. If what you want to achieve is to protect consumers, I think the answer is negative. We do not need a new framework. I mean, to be sure, I think we did focus probably a bit too much on prices in the past, but also it made sense at the time. We have to focus now on innovation and dynamism. But I think it's working. And if you look at the Google cases in Europe, it's a good example of the fact that we can actually capture those companies' practices using the current framework and tools. And the same, goes in the US with all the investigations, the Google case that was announced, the investigations against Amazon, Apple, and so on. If on the other end, what you want to achieve is not to protect consumers, but something else, then you probably do need to change the framework. But then I will ask you a series of questions. First, what do you want to achieve? Then, how would you achieve that thing? Which rules, which standards, and what would you change precisely? I think it's very important to be precise here. And also, it would be important to ask the question, how and why would you get rid of capture? It could be private capture, it could be public capture, it could be false positive, false negative. You need to address all those, and to also discuss the long-term impacts of the new framework you want to implement in antitrust. And if you can answer all those questions and get the majority of the people with you, then sure, change that. And I mean, a good example is the fact that we say that we want now to use antitrust to protect the environment. But my question is, do we really want antitrust agencies to be in charge of that, or do we trust them to do that? And if we do, then what about, for instance, gender equality, or what about racism? And those are the subjects that are being discussed right now in the field. My personal perspective is that those are two important subjects that needs to be addressed by proper regulation and proper experts in charge of those questions. And I'm not sure if I trust antitrust agencies to make sure to ensure the environment, and also, to also make balances between all of those objectives. In cases it would be necessary, and I'm not sure if we want, again, antitrust agencies to be in charge of deciding that the environment is more important than gender equality, for instance, in a case. So again, it depends on what you want to achieve. But as far as consumer welfare is concerned, everything is far from being perfect, but I think we are doing an okay job, at least.
Okay, so are you concerned about recent efforts to bring these new ideas and new proposals to antitrust? And you already alluded to it that, you know, some are arguing that antitrust law is being politicized for broader economic, socioeconomic purposes. So, well, are these legitimate concerns at all, or what are your thoughts on this?
Sure, I think they are, and I know, and we hear that, and that is true, that antitrust is political by nature. If you choose to protect consumers over producers, for instance, well, that's a political choice, and I understand that. But it seems that now we hear something different, which will be to make antitrust just a political tool for achieving something else, something outside of antitrust, which is something which entered the realm of party politics in a sense. And that I think we've seen in the past when this has been done in the 50s in the US, for instance, the results, and I think they were not great results. And so for that reason, although antitrust is political by nature, that's one thing, but I'm worried that we may actually just use it for, again, achieving something else. Some people call that populism with the brain. And again, I'm not sure if we want to achieve anything besides benefiting a few individuals, probably here and there.
Mm-hmm. And so, what are some of the risks to antitrust enforcement specifically associated with some of the proposals out there?
So the way I will frame it is that probably the big picture risk is the capture by private or public interest, which will therefore decrease the common good, or you could call it the total welfare. I think the small picture risk is that there is what we see and what we don't see. And in the way we've been applying antitrust for decades now, we know that if we protect consumers, it's far from being perfect when it comes to other parts of societies or other objectives. And so we now are days and after days are getting better at protecting those other things. So a good example of that is, for instance, merger regulation. We know that a merger between two companies, not always, but can be good for consumers. But we know that it could also be detrimental to workers. And I believe that we are, again, far from perfect, but we understand that. And therefore, we can actually take proper regulation for addressing those other items. And I think the risk is that if we change the goal and if we depart from consumer welfare, then we will see what will be the new objective, right? If we protect the environment, well, yes, we could probably measure that, although it will be complex, but let's say we can. But I think the risk is that what we don't see, all of the other things that will suffer from the new objective, we will have no idea, and therefore no proper regulation where it's needed to actually help in those parts of societies. So I think for me, that's again the bigger risk. And unfortunately, since it is something we won't see, it will be hard to address and hard to measure. And of course, you know, it will again be the door for more private capture and public capture probably.
Mm-hmm. And so one problem with the breaking up big tech movement is that there are too many conflated arguments at the moment, and it leaves us all unclear about what exactly we should be outraged about. Um, are so when it comes to antitrust enforcement, is big necessarily bad?
Well, I would say, I mean, of course, you know, and when I teach my students, the first thing that I say is that, of course, big is not bad, at least not in antitrust. We are very clear, and I think the way we frame it in Europe is actually clearer. It's an abuse of a dominant position. The dominant position itself is not an abuse per se, but in the US, although you know it is being called monopolization, the idea is pretty much the same, and so that's the theory. In practice, however, I fear that because it is true that we don't have all the tools to capture what's happening on the markets, and the tools that we've been using in antitrust are too static, and we know that, but it's hard to create new tools to capture dynamism and to capture the fact that there is no equilibrium on most markets. So it's true that there is a risk that we may want to do something under uncertainty, and I believe this is not a reason why we shouldn't do anything because we don't have the tools, because I think in the next 30 years we won't have the tools to understand exactly what's happening on the market. But that being said, it doesn't mean that because we don't have the proper tools that we can do anything we want. And something that we've been seeing very clearly, at least in Europe, is the European Commission and other agencies using some concepts such as potential effects more and more. And I understand the idea of saying that we will not wait for a company to implement something anti-competitive before publishing the company. If we have the proof that the company is about to do it, let's say potentially it will be bad, and therefore you cannot do that. That I understand. But when it comes to practices that were implemented in the past, to use the concept of potential effects, and again, this is legal under European competition law. In the US, you don't have that concept, but sometimes if you read cases and court decision, it's pretty much the same. I'm not sure if that's something we want to do. And in turn, if all you say is that you prove a dominant position and you say to a company you have been implementing a practice which potentially is bad for consumer, well, it's not really far from big is bad, or you could probably call it big plus practice is bad. So that's where we're at. And some people are very vocal about it and saying, yes, that's exactly what we want. So I think there is no secret here. But again, big is bad. It's coming, and it's definitely getting around.
Mm-hmm. And so you mentioned, Europe in specific cases, but we often look at US tech regulation in comparison to Europe specifically, and mainly that's because, their standards and policies often differ from what we experience here in the US. So can you talk a bit more about those differences?
Sure. Well, I could probably talk about that for hours. So I'm not sure if we want to spend that much. But I think, of course, the big difference is that you have to have a look at each regulation on a case-by-case basis. So it relates to their nature. But of course, then what you could do is that try to distinguish a few trends here and there. I would say that recently in Europe, what we've seen is that there is a call for ex ante regulation. That's the case for the new competition tool, so-called, the new Digital Service Act coming, the new Market Act, Digital Market Act. And so all you see and you hear that again vocally is that we do need to regulate those companies before they implement any type of practice for some sort of structural problems and issues. In my view, this is what I called creationist antitrust. I'm not sure if we can replace competition behind a computer and design a proper policy behind a computer. And I have to say that for now, we haven't seen much of that in the US. I know that there are a few reports here and there, but they are quite timid actually compared to those regulations that I just quoted in Europe. And that's one of the first things now that I ask my students is to read Darwin to try to understand the biology behind antitrust and behind markets. And I think we should really start from there instead of thinking that we can actually design something that will work great for consumers or any other objectives that you may want to achieve actually.
Mm-hmm. So the House Judiciary Committee just recently put out its report on antitrust in the tech sector, and the staff recommended a number of changes to antitrust law and the FTC. So what do you think about some of their recommendations?
So I've heard recently Herb Ovenkamp saying that he said, I can't say that I've read every word of the new report, but I've read more than what I should have. And the same is true for me. It's 450 pages. I would say that I've read probably 3/4 of it, but not every single word. There are things that I dislike, things which I think on the contrary are quite good. The thing that I dislike, well, the first, and we discussed that already, is the idea of a new standard for antitrust violation. It calls for protecting not only consumers, but workers, entrepreneurs, open markets, the fair economy, democratic ideals. And again, I'm not sure if I want antitrust agencies to be in charge of all that and protecting our democracies. So that's one point. The second point is the call for the creation of safe harbors for the press. And that I don't get. If indeed antitrust could protect democracies or democratic ideals, I'm not sure why would you then take the press out of it. It seems to me that quite the contrary, you may want to put the press within the realm of antitrust, since it could actually protect democracy. So that's another point. The fact that the what I call the semi-structural remedies which are being asked, I'm not quite sure if I get it as well. On the one hand, the report is calling for the prohibition on self-preferencing and discrimination. So that's one thing. And it seems to me that those rules are very easy to apply if you only have one infrastructure per market. But if you divide those infrastructure, then those rules will have to be applied and followed regarding many infrastructures. So again, I'm not sure if I understand the logic here of having both semi-structural remedies and those behavioral remedies. And for the things that I like, on the contrary, I think it's great that the report is calling for anti-competitive product designs to be something that at least agencies and courts should have a closer look at. And I think indeed we have a legal loophole right now, which is that if you do something within a contract, antitrust agencies and courts understand that, and you may be punished. It might be an infringement to antitrust. However, if you are to do something within the coding and the programming of a software or a platform, antitrust agencies are just not having a look at that for now. And even the recent Google case in the US, it's again a matter of contract. So I think it's necessary. I see the dangers of letting judges and courts entering the design of softwares, but I think we have no choice but to do that. And another point that I like is the call for increasing the budget of antitrust agencies. I think it's more than necessary, and I know it's going to be hard politically to explain, to go to Congress in the US and explain that because of blockchain and because of AI, you do need to increase the budget because agencies need to be more proactive. And for now, they are just reactive. 90% of cases in the US and in Europe are just coming from basically from leniency applicants. And that is working in the field where humans are doing most of the practices. But if you put a bunch of computers and blockchain in between, I'm not saying you will not see any leniency applications, but you will probably see a decrease. And we see a decrease already for the last 5 years. So I think it's necessary that we increase their budget. So I think that was the good part, one of the good parts of that report.
Okay, so let's move on to the current suit against Google. So the DOJ, as you know, filed suit against Google for illegal monopolization of the search and ad markets, which pretty much kicked off one of the largest antitrust cases in US history. So the alleged consumer harms included in the complaint are a reduction in the quality of search services, including privacy and data protection, fewer choices in general services, and impeding innovation. What are your immediate reactions to the suit?
So, contrary to the report that is 550 pages, the decision, or at least the complaint, is only 60 pages or so. So I've read it entirely. I know we heard that it was the new Microsoft case. So I understand what some people would say, that indeed those are two tech companies. And it's true that in the US, we haven't seen so many cases regarding Sherman Act Section 2. So I understand here the comparison. However, if you look at the claims, those are totally different. In the Microsoft case, it was about Microsoft using the infrastructure, which was the Microsoft operating system, for impeding competition on top of that infrastructure, right? So it was regarding the browser, it was regarding the Windows Media Player in Europe, and so on. The new Google case is totally different. It's about Google doing something potentially anti-competitive towards other search engines which are on the same level of the market. So this is in a sense a horizontal case, where the Microsoft case is very much vertical by nature. And I think, to be frank, the Microsoft case and the idea of infrastructure on top of which you can build something is actually more important and potentially more detrimental to consumers. So I'm not saying that what Google did here is perfectly pro-competitive. We will see. But it seems to me that we've been waiting for so many years, and I'm wondering if that's really where consumers are hurting the most when it comes to any types of markets in the US. So that was the first thing. The idea of prohibiting anti-forking agreements, I think that could hurt open source systems, and we've seen part of the open source community to actually be vocal about that, and the fact that potentially, well, you may want to impose some sort of compatibility between your different versions of your system. Otherwise, you may experience what happened to Linux, right? Where you have a bunch of different versions, they are not compatible with one another, and that's the end of it. The European Commission, by the way, did the same here, so there is no difference. I was disappointed in a sense that we've seen nothing about what I called predatory innovation, which is something that I discussed already, the design of products which could be anti-competitive. I'm not saying that Google did something anti-competitive there, but I think it would have been interesting to study those claims. And overall, I could see some of the other claims which they actually mimic the ones made by the European Commission. And I understand that, why it would be easier for the DOJ and the states in the coming weeks to mimic the European Commission. I think, on the contrary, it's also easier for Google because they've been working on similar claims for a while, and there is a risk if potentially that decision differs from the one that was published by the European Commission. Then we will see a divide between EU and US antitrust. So I think it's a risky business, and for the rest, again, we will see how it goes. But those were my reactions.
Any predictions on where this lawsuit will lead to?
Well, I mean, you know the saying, prediction is very difficult, especially if it's about the future. No prediction. It will depend also on the judge being appointed. I think that was announced a week ago, and so many things. Again, I'm not sure if that's where consumers are hurting the most. It seems that some practices, indeed, you could discuss whether they are pro-competitive or anti-competitive. But again, it seems to me that discussing competition between Google and Bing and DuckDuckGo, I'm not saying it's not important, but it seems to me that it's more important the way Google is using the infrastructure to actually shape every services and products on top of it. So that's not a prediction. That was disappointment, and that I can say right away without being wrong.
Mm-hmm. So we have the DOJ's Google case, and a Facebook antitrust suit is expected out of the FTC later this month. And there are some antitrust probes into Apple and Amazon now pending at the DOJ and FTC. And that's on top of, we talked about the recent report. So what is the impact of these proposals, events, and developments happening here in the US on everything else that's going on with antitrust abroad, so on a more global framework?
Well, it is being discussed, that's for sure, and at least in Europe, and I know in some other countries such as Brazil, it is being discussed. I think the bigger impact will be actually invisible. I mean, sure, you may see a reform here and there that is quoting the reports, or implementing something that was asked in one of those reports, but overall, it's definitely moving the direction in a sense. And that's invisible, but it's something that is happening. Now the question is, is it something that will be there to stay, or we will see probably a different movement in the coming month, in the coming years. I guess overall the impact depends on whether on first, who's elected president in the United States tomorrow. Second, do they stay united, this side pushing for more infrastructure antitrust, Is the other side uniting, which is a possibility? And overall, it would depend on the robustness of the arguments. But that's on purpose something that I mentioned last, because I'm not sure if that's actually the reason why some of those arguments and reforms will be implemented or not. But again, I mean, it's a complex word, and I don't want to be proven wrong in just 1 or 2 weeks, which is a possibility. So that's all I would say regarding the future.
Okay, so election day is tomorrow. Any predictions on what would change, if anything, if Biden wins or if Trump wins?
Well, again, prediction. One that I could probably make is that if Biden wins the election tomorrow, I think overall antitrust will be less politicized than if Trump is being reelected. And that's something, that 4 years ago we thought that antitrust would become just a Trojan horse for other things and other objectives. It hasn't been, but now we know that in the report, the Republican Party and Republican congressmen were pushing for certain measures to actually address the fact that social media may be biased against Republican ideas. And I think we will see more of that if Trump is being elected, probably less if Biden is being elected. That being said, again, this is just a prediction, which is here to be wrong. So we will see how it turns out.
All right, and so we're getting close to the end of the webinar. Do you have any concluding thoughts for our audience?
Sure. There is something, I mean, overall, I think a subject which is not being discussed probably enough is the one of institutions and the way we design antitrust agencies and the way they prepare themselves to tackle new issues and new technologies. I've been very pleased to see that in the US, the DOJ has been training part of its staff to blockchain, and I know they've been training also part of the staff to AI. But that's something which I think we have to discuss, which are the institutional design of antitrust agencies, and something which is almost never being discussed. And I know that internally some antitrust agencies are investigating that field as well, which is to use technology to actually improve antitrust agencies and improve their processes here and there. So that's something which to me is very interesting. Should you be interested in studying how technology could help antitrust agencies, please be in touch, because I think we have to put some efforts here in the field to actually make technology something which could benefit the common good by improving antitrust agencies on top of providing us with services and products that we care about. So that's the thing that I wanted to say, I guess, to conclude, which is probably a more positive note than just complaining about the fact that antitrust might be going in a direction which is not probably the best.
Well, I'm glad we're concluding on a positive note. So with that, thank you, Thibaut, for sharing your time and thoughts with us today. And I'd also like to thank the audience for tuning in. Thank you all, and have a great day.
Thank you very much. Bye-bye.